40 years ago. Who cares? Okay, that's political.
Good morning, good afternoon, good evening, wherever you are in the world. Welcome on behalf of International Broadcast Media, IBM TV, to The Lawyer's Den. I'm your host, William F. Tresvant, and I'm pleased to have you join us today. First, I want to just take a moment and acknowledge our audience out there, and in particular, a gentle lady that I had the opportunity of speaking with this afternoon about the program. First of all, we appreciate all of our viewers, and for our, at least the colleague I spoke with this evening, we welcome all feedback and all input to our show. We find it dynamic, we find it interactive, and it's part of our commitment to bringing you the best possible broadcasting we can, at least in this program. Now, with that having been said, it is my honor, it is my distinct honor to introduce my erstwhile colleague, my friend, a well-educated JD, MBA, LLM, three-time state chess champion. Indeed, he is a chess master, and that's a real title, as well as being a leader in media and financial planning. My friend Nick, where are you?
I'm just trying to wake up here, Bill. It's good to be back on the Lawyer's Den. You know, it's we have a lot of shy people here, but we're trying to bring out the best of them. So, well, do you want to go through the panel that we have today?
Yes, we can bring them on board.
Okay, I'm going to bring them on one by one. And this gentleman hails from the University of Southern California. And after he went to the USC to receive his bachelor's degree, getting in on, I'm not sure how he got in there, but anyway, he somehow got into USC. There's a whole story behind it. It'll be the subject of another one of our shows. He went to the Ohio State University, received his law degree, his master's degree also in University of Alabama, and a master's in law, which is a teaching degree at NYU. And this guy actually does teach law at Georgia College. Let's bring in the professor, Adam Lamparero. Adam, professor.
Great to be here.
All right.
Welcome. Now we go all the way to the great state of Utah, where this person actually received his bachelor's degree and his law degree from BYU, and received a master's degree, another teaching degree in law from the George Washington School of Law, and now is the assistant attorney general for the state of Utah for constitutional defenses. Let's bring in Jeff Teichert, our constitutional expert. Jeff,
happy to be back.
Every now and then we'll talk about constitutional law. Now that we have three people right now on the panel with teaching degrees, we have to go find one more that has an LLM. And this lady actually went to the University of Denver after she was living in, in the Baltic state somewhere, Lithuania. Then she received her law degree from the University of Denver, her master's in law from the University of Denver. Let's bring in, now living in Miami, Florida, Guidry Stantadai. Guidry, welcome to the show. All models go to South Beach, but we'll get into that later on in the program. We know about South Beach, so I guess that attracted you. Anyway, now our last panelist. This gentleman actually went to Fordham University, which is in New York City, by the way. Then he went on to the State University of New York at Buffalo. He shuffled off to Buffalo. Then he turned around and went back to New York, where he practices in New York City. He's our street fighter. Let's bring in Fernando Leal. Fernando, welcome to the show.
Nice
and of course, we have the Den Master, who's also an attorney, and he's also went to Fordham and the State University of New York in Buffalo. He proudly, for a change, displays the Buffalo Bills behind his desk. That is the Honorable Bill Tresvant. Bill, Den Master, welcome to the show, and I guess you're going to have to lead off and let us know where these the den goes.
Okay, well, this evening, for today's show, it's going to be really interesting. We're going to cover a topic that most people don't talk about. However, it deeply affects your pocketbook, and it affects our world. It's essentially called the Chevron Doctrine. And while you're unfamiliar with it currently, you will be, and you'll see how its octopus-like tentacles affect every single portion or piece or aspect of your life in ways that you just did not know. But for that, as you know, with each show, we begin with our subject matter expert. And today, leading us off for our briefing is Jeff Piker. Jeff, are you ready to explain to our audience the Chevron doctrine, why it's important, well, what it is, why it's important, and why should our audience be concerned about it? Jeff?
Well, I'll do my best. Chevron was a 1984 United States Supreme Court decision. And if I could go back and take any Americans watching at least to their, high school civics class, we learned that the Congress makes the law, the president enforces it, and the judiciary interprets it. And Chevron changed the balance on all of that. So one thing that Chevron said was that when a court reviews an agency's construction or interpretation of a statute, if it is a statute that agency administers, that the court is confronted with two questions. First of all, has Congress spoken clearly to it? And if they find it's clear and unambiguous, they'll follow it. Mm-hmm. But if not, or if it leaves gaps, they're saying that the agency can come in with interpretations of the law, and that the courts are bound to follow those unless they're arbitrary and capricious. And it stacks the deck against people who doing business with the government in one way or another, regulated industries and so forth. And that's everything from banking to insurance down to livestock ranchers grazing on the public lands. And the other thing they can do, and this is more under the auspices of the Administrative Procedures Act, but they're permitted, the agencies are permitted to write rules, which also interpret the statutes. And if you look at the laws passed by Congress, they fill two bookshelves of normal size, two shelves, not two bookcases. But if you look at the Code of Federal Regulations, which is all of the administrative interpretations, it fills a gigantic wall of your library. And so most of the law being written is not being written by Congress, not passed with the partisan compromises and so forth that we expect in legislation. It is written by the political appointees of one party or the other, and rewritten often when a new party takes power. And really one of the president's major powers under this scheme, which I don't necessarily believe is constitutional, because I think it delegates legislative power to the executive.
Okay.
But one of the big problems is that they don't give you due process of law. The presumption is against you.
Okay.
Both on the facts and the law.
Okay, so let me just drill down really quickly so I can get this straight for our audience. Essentially, whenever we hear politicians running for office and saying they're going to cut the red tape, this is exactly what we're talking about. All of these laws that nobody knows about, all of these rules that have been written by people that we don't know, that have never been elected, that simply work out their jobs, that are part of the bureaucracy, that one day when you take your case to court, suddenly you're slammed with like 15 books saying you didn't do this, you didn't do this, you didn't do that. Am I correct on that, Jeff? The red tape portion of this?
Well, yes. And I would add to that, you're not even going to court at first. You have to do under the Administrative Procedures Act what they call exhausting your administrative remedies, which means that before you can even go to court, if you have any right to appear in front of the agency in some fashion, you have to do that and go as far as you can with the agency before you're even allowed to appeal that in court. And as lawyers know, when you appeal, there's a different standard of review. They look at the lower court, or in this case, the agency's factual findings and basically accept them as gospel unless they're arbitrary and capricious.
Okay, so what I'm the sense that I'm getting is that essentially it's like going to a casino and we're playing with the casino rules when we're dealing with all these regulations. That would be a fair characterization, wouldn't it be, Jeff?
Oh,
Okay.
Yeah, for sure.
Okay, great. Now let's get to our panel. I want to first start off with, and we're going to go in this order. Adam, you have long been, because I'm going to go Adam and Guidry, you're on deck. But Adam, I want to start with you. You have long been a champion, a fighter against these unelected oligarch-like structures running our very lives. Where do you sit? Because it was this one case by your conservative icon, Scalia, who said, hey, I believe in Chevron and I believe in delegating these authorities to administrative bodies. And now these administrative bodies are using it to strangle business. So, Adam, where do you come down? You come down on behalf of your leader, Anton Scalia, and Chevron, or against? Adam?
I completely support Chevron and Justice Scalia's reasoning. All that Chevron says is that the courts will defer to an agency's interpretation of the law when the law is ambiguous and when that interpretation is reasonable. And that is what I've been saying all along. When a law or the Constitution is ambiguous, judges have no business getting involved in the democratic process. That's what Justice Roberts said in National Independent in the Obamacare case when he upheld Obamacare by saying, because the Constitution was ambiguous on this issue, we should defer to the legislature. I agree that we should defer to agencies when the Constitution or the law is ambiguous because we don't want judges exercising this power to do whatever they want, whenever they want, for whatever reason they want.
Okay, all right. Okay, Guidry, your good friend and your colleague, Adam, who on the one hand doesn't want judges making decisions, but on the other hand wants these people that we don't even know, these administrative people, these lifelong bureaucrats making decisions. I mean, Guidry, what are your thoughts on that, please? Guidry? Oh, we're having a technical issue. All right, let's go to Fernando. Guidry, we'll figure you out. Fernando, your thoughts?
In all honesty, these are the decisions by the courts that, as a civil litigator, get under my skin because it's the court hunting its responsibility because they don't want to have any more cases on their dockets. I see this, the whole point of having courts and judicial review is to look at those gray areas that are unambiguous and to try and marry it to the law and to figure out if it should be there, it shouldn't be there, what should be done. That's where lawyers make their money, in all honesty. It's fighting in the gray areas. Which one of these things is not like the other? Also, I see this decision as destroying separation of power because now you get agencies who make up their own rules and then they're enforcing their own rules and then they're interpreting their own rules. So they're pretty much judge and jury along with executioner. And that to me seems to go against the spirit of the Constitution. I mean, somewhere in my brain, I remember from political science class, I think it was Montague or Locke or Rousseau, one of them, who says, and I'm paraphrasing, that you cannot give the individual who makes the law the responsibility of interpreting the law because it leads to tyranny. And a lot of these agencies are tyrannical in their approach when you go there and you try to get something accomplished.
Okay, now I want to hear, and this is particularly important for our audience, Nick, please, because Nick, I think you have a very unique view on this matter. And do you want to explain to the audience why you feel so passionately about this and what your position is?
Sure. Well, of course, Adam is wrong again, but the thing is, he hasn't had Chevron stuck up his rear like I have. Let me explain to the audience so they really know what Chevron is. It has nothing to do with gas. The only gas you're getting is the blowing gas from a bureaucracy, a bloated bureaucracy that interprets the law basically any way they want to if it's ambiguous, which means if you and I were in a dispute, Bill, and it's a civil dispute, and I drafted the contract and it's ambiguous, the difference is actually given to you because I'm the guy who screwed it up. Okay. I mean, that's been old contract law for years. But when you're dealing with the government, if I'm the government, I drafted an ambiguous language, it's construed against you. In other words, I get to play freely with how I'm going to interpret the law against you. So it gives the individual that Adam used to support basically no rights before a government agency. They get slaughtered. I don't understand why Adam, who was so in favor of individual rights, now allows Chevron to gas over all the individuals.
I'd like to throw a flag here, Bill.
Okay, Adam, you've got your flag. What do you have to say?
I want to be very clear with the audience. Where a statute, a law, or the Constitution is ambiguous and therefore subject to reasonable interpretations, we should defer to the democratic process. We should defer to the people. We shouldn't give 9 unelected judges the right to interpret that in whichever way they want, because when they do, all they're really doing is implementing their policy preferences.
No, Adam, I get your argument, but I really want to just kind of drill down for a second, because what Nick said is kind of, it really kind of rubs a bit.
No, because Nick is missing the point. The point is this. If an agency issues a regulation or interprets the law in a manner that violates the Constitution, of course the court should step in. The court's job is to enforce Constitution.
No, I understand that, Adam, but I want to give a real-time example. Let's just say it's just you and I, okay? So we've got a statute. It says, hey, listen, the neighbors can't throw trash on my lawn. And then, some administrative agency then writes a rule. So you and I have a dispute. You're the government, and I'm the guy that says, hey, listen, this law says that can't happen. You come along and you say, well, yesterday I took a look at the law and I decided that, a trash bag is not really trash as I define it. And I say, well, then what is trash? You say, well, it's got to be an oil tanker. And I said, but listen, but what about the McDonald's bags? You say, well, it's not McDonald's bags. We go to court. The judge says, well, okay, well, Bill, you lose because Adam he's the one in charge of enforcing the law. So therefore he gets to decide what trash is. And I'm like, well, why can't I decide what trash is? Nick, do I have that wrong?
No, yeah. You got it right. They are the thing is in civil law, I'm going to try to help Adam out here. You have a judge because you need a third party arbitrator. And what we have under Chevron, the agency is the judge, the agency is the jury, and the judge and the executioner.
That is false.
You as an individual and you as a corporation have like zero rights. And I know because I've got Chevron problems stuck up my rear right now. I got to tell my client. I got to go to my client and tell him, look, our government is so powerful. These bureaucrats are so powerful. They are the judge. They are the jury. They are the executioner under Chevron. You lose, even though you have a reasonable position.
Okay, no, Adam, I'm going to come to you, but I just because we're all arguing. But Jeff, I just want to get from you because you're our subject matter expert on this one. Let's just be clear. So, an agency, let's just say the EPA, the Environmental Protection Agency, they issue a ruling. It says these are our EPA rules. Okay, then there's a dispute. They go to court. And the judge looks at the EPA and they say, this is how we define the law. And then whoever's fighting the EPA says, this is our interpretation of the law. Who wins under Chevron? I need your microphone.
The EPA wins those virtually every time. Now, I'll give you an example I'm slightly more familiar with, having litigated a bunch of cases before the U.S. Forest Service. If you're a livestock operator, a rancher in common terminology, and you have a permit to graze so many cattle for so many months on the public domain, and they come in and say, we think that you've abused the land, we're going to cut your cow numbers in half. And you go in and try to appeal that. Imagine if you're walking into a courtroom and see in the black robe, up at the front on the bench, the person who made the decision you're contesting. That is what you are facing in an administrative appeal. Your judge is the same person who's prosecuting you. How in the world does that include due process? And literally, your appeal in the Forest Service system, it isn't to an administrative law judge, which I also think is a usurpation of judicial power. Many agencies have administrative law judges that judge cases before they can ever go to a real court. And they're not bound by the same due process rules as the judicial.
Point here.
Okay.
But in the Forest Service system, you don't even get an administrative law judge. You get the next line officer above you.
Okay.
And so he was probably in on making the decision to start with. Then he will use his own experts and defer to his own experts. So your expert witnesses will be thrown out or discounted.
Right.
And they will defer to the agency's interpretation of the law and throw yours out. It is a crock.
It used to be called a kangaroo court, Bill.
Okay. Gidru, you're out for a minute. Now come back in, and Gidru, because I know this works over in immigration law as well. I mean, what's going on, Gidru? How are you looking at it?
Well, as I wanted to say, it's really difficult for me to pick a side, because here, as Adam mentioned, based on his favorite Supreme Court Justice Scalia, he really supported this decision in Chevron deference because it provided predictability. According to him, we need to take from the court a power to make a law and leave it to the Congress. Yet, right now, where I have an issue with it, the agencies are absolutely beyond enforcing the rules. They actually manipulating the rules. It's very, very difficult to have unambiguous provisions that are right now being made as a big deal and really affect a lot of parties, starting with businesses going to individual lives. So I do have an issue with Chevron doctrine at this point, but I also don't want the court to start making the law. So again, how do we need to take it away from the agencies that actually were appointed by our executive power and put it back to the Congress and really make them to leave those blanks, those gaps blank, and therefore causing such a chaos and misunderstandings.
Okay, Adam, we're coming to you, and then I'm coming to you, Fernando. Fernando, you're on deck. Adam, look, all of your colleagues so far are saying that, they can't see, they think you're a hypocrite. Unelected judges, no good, but unknown bureaucrats, good in your camp. How does that work, Adam?
My colleagues are wrong and they are misleading the audience. First, every individual subject to a regulation by an agency always has access to the courts, the appellate courts, the federal courts, the U.S. Supreme Court. Now, to be clear, the courts only defer to agencies when the law or regulation at issue is first ambiguous, and two, the court deems that the agency's interpretation is reasonable. So the court has to make a determination of reasonableness. And when the court says that the agency interpreted an ambiguous law reasonably, the absolute right choice is to defer to the agency. That's the point. You don't want courts enforcing, making up law out of thin air. If the courts determine that it's a reasonable interpretation and the statute is capable of different interpretations, I defer to democracy and I don't support dictatorship.
Jeff,
unelected judges.
Okay, well, Jeff threw a flag. Fernando, I'm coming to you. Jeff, your flag, please.
Okay, well, what Adam is missing is, and I can't believe I agree with Gidru and disagree with Adam. I mean, the world is upside
First time for everything.
But first of all, now Justice Scalia was a big proponent of Chevron and all this. I think he was largely wrong about that.
Don't call me a hypocrite.
His protege, Justice Gorsuch, actually has questioned whether Chevron ought to be overturned. Hasn't said he would overrule it, but has at least hinted that he might. Now, what I was going to say is, number one, when the thing Adam is missing is when this goes to court, finally, after a year and a half or two of administrative proceedings, when the agency has made its decision, they get an appellate standard of review when you go to court. So you don't get a big evidentiary hearing. The judge is going to decide your case based on the administrative record, which is controlled by the agency.
I'm throwing a flag here, Bill.
And
okay,
secondly,
well, that's your second one, and we're going to get to you, but you guys just, okay, go ahead, Jeff. Make it quick.
Secondly, I'll quote directly from Chevron to one thing I think is a real problem with it. Sometimes the legislative delegation to an agency on a particular question is implicit rather than explicit. In such a case, a court may not substitute its own construction of a statutory provision for a reasonable interpretation made by the administrator of an agency. That is that is abandoning judicial power. The principal thing we have courts for is to tell us what the law means, to interpret it. Now, I grant executive agencies have to interpret it so far as necessary to enforce it, but they're going way beyond that. They're making rules that have no basis in the statute at all. And I think when a gap exists in the statute, as Justice Stevens wrote in the Chevron decision, a gap, well, maybe that gap is there for a reason. Maybe they didn't want to speak on a particular issue. So why should the agency get to come in and fill that gap with whatever they dream up? It's undemocratic.
Adam, very quickly, and then Fernando, please. Adam, quickly, and then Fernando.
Jeff is describing the appellate process in almost every area of the law. In criminal law, there's what's called an abusive discretion standard where you defer to the factual findings of the trial judge. There's nothing unique about this. My point is simple. When a law is subject to various reasonable interpretations and it's ambiguous, we should be allowing the agency in a democratic process to make that meaning rather than unelected judges deciding what they think it should mean. That is outside the scope of judicial review. It's anti-democratic and it's wrong.
Fernando. I mean, makes sense because Fernando, you're a litigator, you're a street fighter, and they're all talking about, boots on the ground. What happens when you walk in and the guy who made the decision that you're arguing against is the one that you're appealing to? How does that work, Fernando?
I turn to my client and I tell him he's not much we can do. Let's say a couple of words and we got to get out of here because it's pretty much over at this point in time. And Adam is a hypocrite because the last time I checked, Adam stomps his feet and tantrums and says that he's a
Well, I believe in limited judicial review.
Why don't you just shut up and let people talk? It's annoying that you constantly have to talk over people.
Okay.
Like,
all right.
start your mic off.
Okay, your point, Fernando.
The fact is constantly saying that he is a strict constructionist, that we have to interpret the letter of the law of the Constitution. Yet, all of a sudden, it's okay for one branch to upset separation of power, usurp the powers under Article 3 for the judiciary, and take it off for them. People who are unelected officials, because none of these agencies ran for office. None of these people were elected by the people. They were appointments, either the president, by a congressman, a local political party office. They're not elected officials, yet they're sitting there having a hand in creating legislation.
Okay.
They're sitting there enforcing the legislation, and then they're sitting there being the judge at the same time. That's not American. For the people and by the people. That's tyrannical.
Okay, Nick, I'm turning to you, and then I'm coming to you, Guidry, again, because Guidry, I'm coming to you specifically about.
I'm gonna try to explain this in a way the audience and Adam can understand this.
Nick, but I have a first question. Sure. How much is it costing you? Is on the line right now with your client for our audience?
Oh, it's over $800,000.
Okay,
and I got to go tell him he's going to lose.
In your case, it's $1 million.
It's about $1 million claim. Yeah, right.
Okay. Now tell us, please.
But the thing is, let me explain. Since Adam, I believe, played sports like at USC, or he tried to play baseball, and imagine the baseball batting box is ambiguously defined. It's up to the umpire. Imagine even further, the umpire is your opposing team. In other words, the opposing team coach gets to be the umpire. How fair is that baseball game going to look to you, Adam? Probably not too fair. That is the law in the United States.
No, that's a lie.
Today under Chevron. And everybody here who practices, who's had cases, including Jeff, myself, in front of these administrative agencies, realize that we go into a situation and there's two different interpretations. We take a reasonable interpretation, which we did. They take a reasonable interpretation. We lose. We don't even have a chance to argue why our reasonable interpretation is more reasonable than theirs. Okay, and that's how bad the Chevron decision is. The problem I see is people around the United States and even people in our audience don't even know that this goes on. Those government bureaucrats are more powerful than individuals, and you lose your individual rights and liberties in the United States all the time because of Chevron.
Okay, now Guidry, because I want to take a bit of a turn here. Now, Nick gave us an example of a million reasons why the Chevron doctrine is wrong and or should be adjusted. We know, according to Jeff, that the Supreme Court has kind of been wheedling this way. But in your particular experience, the Chevron doctrine has it impacts lives, as you mentioned before. So it's not just money in Nick's case. In your case, it's whether or not people get into the country, don't get out of the country. Tell us about that, Guidry.
Well,
I know.
you know, it's, when I see Chevron doctrine, I really want to trust the agencies. So in a perfect world, we would have federal agencies structured to fully represent what they stand for. But now when we look into politics, we can see that the executive power appoints people to certain agencies with their agenda. EPA not necessarily would have, protecting the air pollution. If they represent, they have a different donors or different interest of the people who are staggered in the government. And this past president indicated that without any embarrassment, appointing people for agencies that really, including the immigration affairs, that really had completely different interests than the one that was set when the agency was created. So number one, so when we have agency that functions and is driven very politically motivated, and we give such unprecedented power for an agency to interpret its ambiguous law, and we have a lot of attorneys. Can I say one thing, that how many legal statements you have read that were in the contract, in different amendments, in different legal documents, that we would say like, oh my goodness, it is absolutely clear document. Law is ambiguous in its nature. And as Adam pointed, yes, ambiguous law can have multiple reasonable interpretations. And what's the problem there? I see a big problem with the word multiple reasonable interpretations. And it's not only reasonable, it also says rational interpretation. So it's really, really ambiguous solution for ambiguous documents. So really, Chevron doctrine, I think, completely disbalances the powers, and in this point, federal government has unsubstantiated authority and power to present and write the laws that they have.
Okay, Jeff, I'm coming to you, and Adam, I'm coming to you right after Jeff. But Jeff, I have a specific question for you as we go along here, and that is, with the recent appointments of the new, the most recent justices of the Supreme Court, who all come from, originalist types of thinking, or the school of thought that Scalia belonged to, who was the forefather or the author of the Chevron deference, there is some significant questions. You mentioned Gorsuch. Isn't it also true with Kavanaugh? And then the other one, the newest one, we don't know. What's going on? Because hasn't the court been narrowing this? Jeff, can you tell us about that?
Well, yeah, I think Adams' interpretation is largely the way Justice Scalia thought it, that it was better to have the executive branch in control of something than the courts, because at least the president was elected. I think Justice Scalia spent too much time in the executive branch, honestly. And that's one problem with appointing only government attorneys to judgeships, is you have a very pro-government approach that gets adopted. And to use Guidry's little analogy about contracts, she says various provisions in contracts can have various different meanings and feel ambiguous. Quite true. Now, what do you do normally with ambiguities in contract law? Well, they are construed against the drafting party. When it comes to the government, it's exactly the opposite.
Right.
The person who wrote the rules gets to interpret the rules on the fly while they're in the middle of screwing somebody. So, and then when it goes to the administrative law judge or the agency line officer or whoever makes the decision, you're seeing the person who made the decision, figuratively speaking, in that black robe at the front of the room. It denies due process.
Okay.
That's correct.
People need to be in front of a neutral decision maker and realize that they've got a fair shot.
Amen.
Rather than somebody who
Right.
has their thumb on the scale for 200 extra pounds.
Okay, Adam, we're coming to you. I mean, is it like, I mean, because what I hear is I going to court as an individual when I'm fighting the government, I might as well be going to the local county fair and going to the carnival, because there's some guy behind the scene who has his thumb on the meter when I'm trying to win a prize, a stuffed animal for my sweetie. What's going on, Adam? I mean, is the thumb on the scale and you're actually against the little guy that you want to protect, or what? I just want to win an animal for my sweetie, Adam. I mean, why are you being so unfair?
What's going on is that this panel is entirely misrepresenting the law on Chevron, and it's attacking me and misrepresenting my position. Courts should always have the ability to rectify constitutional wrongs based on a reasonable interpretation of the text. Individuals have a right to go before courts to contest agency actions, and they often do so. And the courts will only defer to agencies when A, the regulation in question is ambiguous and subject to reasonable interpretations, and the court finds that they are, in fact, reasonably interpreting a law. So in that situation, there's no justification for the court substituting its version of reasonableness for the agencies. I don't believe the court have that power. And you're all misrepresenting this. As far as you go, Fernando, telling me to shut up, you can attack me personally. I don't care. But you do not undermine my argument in any way whatsoever. Okay. So go personally.
Okay? Adam, we're going to hang on, because I have a quick follow-up for you, Adam, and that is this: is that if it is so clear-cut as you eloquently argue, why is it that Gorsuch, who comes directly out of the Scalia school of thought as an originalist, is beginning to question openly, him along with Kavanaugh and perhaps even Clarence Thomas, that they think that Chevron perhaps went too far and needs to be curtailed? I mean, because isn't it true that a couple of cases have been cutting off, trying to narrow Chevron? That's true, right, Adam? We can agree on that, right?
Yeah, and I would also say that judges are political, and judges have big egos, and they want power, and Gorsuch is one of them. I side with Chief Justice Roberts, who in National Federation of Independent Investors versus Sebelius said, courts should defer to the coordinate branches when the Constitution is ambiguous. They have the power to say what the law is, but not what it should be. And when a court determines that an agency's interpretation of an ambiguous law is reasonable, the court has no business stepping in.
Okay, well, but the court's re-examining that now, the Supreme Court, so they're making a change, even though you think it's quite
Chevron was 9-0. Gorsuch is in the minority, as he should be.
Okay, well, Fernando, we're coming to you.
No, Chevron was 6-0.
I'm sorry, Guidry. Thank you for that clarification.
Chevron should be 0-6 going.
I was referring to a different, closely related case, but the point remains the same: that the majority of the court agrees with me, not you.
No, hang on, Adam. Guidry, what was that score again? Because I mean, the scores don't lie. What was that score?
No, it was 6-0.
6-0. And
so
Adam,
three judges
I said it was unanimous.
Recused themselves.
Okay, all right, well, fine.
It was a unanimous bad decision.
Yeah.
Well, the court agrees with me and disagrees with all of you.
Let me throw one more flag on Adam.
And I'm on Scalia's side, not on.
Jeff's second flag.
All right. So here's the other thing that Adam is missing. If I'm a trial level judge and somebody brings an administrative appeal to me, and I know that if it gets reviewed by the appellate court, that the agency's interpretation is going to prevail unless it is arbitrary and capricious, and I don't want to get overturned on appeal, what am I going to do? Now, going into a court against an arbitrary and capricious standard, you're going to lose every damn time. And that's the problem. The judges don't want to get overturned on appeal, and an appellate standard of review is held against them as well as above. And when has this person ever had a fair day in court with an impartial judge?
Jeff, it's the same thing in criminal law with the abuse of discretion standard.
I know, Adam, we're going to get there. Fernando, because I'm turning to you to get to this issue of how it works in the criminal system. Because, my limited experience has been that at least when the government's prosecuting, everything they say is true. The government gets the advantage. They get to put together the case. They get to present the evidence that they want. And then if there's a discrepancy, the presumption goes to the other side loses. Fernando, what's your understanding of how it works in criminal law based on your experience?
In terms of, can you repeat the question, please, Bill? There was
Okay.
some background noise, and you got cut off.
Okay, I apologize. Adam keeps raising the notion that this works the same way in the criminal side as by way of a judicial review. What can you explain to our audience about how it works as you understand it?
Well, as I understand it, if you're in criminal court, isn't the presumption of innocence always there? And you're going to analyze what's going on, and then it's going to go towards the defendant, and he's going to go free, because it is better to have a guilty person free than 10 non-guilty people in jail.
Exactly. So that within the context of criminal law, the presumption and the deference is given the opposite way, because the burden is on the government to prove that the person is guilty, rather than
beyond a reasonable doubt.
That's not what I was saying.
Okay,
Have
well,
to prove beyond a reasonable doubt.
I'm just trying to clear it up, because on the criminal side, the individual who's fighting gets the presumption, whereas on the civil side, the government gets the presumption.
But the appellate courts wholly defer to the trial court.
But Adam, can I throw a flag? Okay, because it's worse than he thinks, and this is in my tax practice of 37 years. We take a reasonable position. We even ask the government,
like agencies.
We ask the government agencies to clarify their regulations. They refuse to do so. Why? Because it gives them tremendous power. They can make up the rules literally as they go along, and we have to abide by that. Okay, so we're at the complete total mercy of these government agencies. In the specific case, I'm right now with the Pension Benefit Guaranty Corporation. They're moving the goalpost along, knowing that, well, there's deference to us in an ambiguous statute, and to heck with you. So what you're saying is this, and I guess Xi Jinping and Vladimir Putin would agree with you. Him and his colleagues should have ultimate power rather than an independent judiciary. I would like to be able to go mano fairly in front of a neutral judge, but I don't get one.
Because courts have to determine that the interpretation is reasonable, and you still have
mine is reasonable too, counselor.
You're the one who wants to entrust non-unelected
mine is reasonable
to make law for an entire nation. You're the one who's the oligarch. I'm the one who's supporting democracy, and it's sad that this panel continues to misrepresent.
Counselor, mine is reasonable too. If you have a reasonable position, and I have a reasonable position, but I'm just a citizen of the United States. I'm a citizen of the United States, but you're the all-powerful government, which you seem to love.
So you want to have judges say it's a reasonable interpretation agency, but ours is more reasonable.
Yes, exactly.
That's not law, that's politics.
Okay, now hang on, Guidry, I'm going Guidry, Jeff, and then Fernando. I'm going right down the bottom line. Guidry, we've heard this kind of back and forth. What are you thinking about it? Because you came out undecided in terms of which way it goes. And in your case,
I am joining Nick's camp, and I'm very proud of it because, I don't think that it's really a solid question at this point. When really considering that, we need to have separation of powers, and federal government has way too much authority. And as Jeff mentioned in the beginning, we have Congress to write the laws, we have executive power to enforce it, and we have judiciary power to interpret it, and we do need an independent judicial authority. Unfortunately, we don't have it, and I'm supporting Nick.
Okay, now, Jeff, I
overturn, baby. Okay, go on. Overturn it.
All right, now, Jeff, I've touched upon it with various things. Nick with the Pension Guaranty Corporation and $1 million, at least just in one case at stake, in people's retirement and pension plans. Guidry with regard to immigration law and people's lives, whether they get into the country or they don't, or who's sent home or who stays. You've been talking about Western ranchers. Exactly how broad is this principle? Because those are just three areas. What are your thoughts, and what other areas does this octopus have its tentacles in, Jeff?
Oh, it's everywhere. I mean, the Bureau of Reclamation that oversees dams and stuff, they have tremendous influence over water rights and water law and a whole bunch of other areas of private concern, and what they say goes. And I mean, you can go down the list of agencies. The Interior Department is the biggest landholder by far in the United States. Millions upon millions of acres of land. The U.S. Forest Service has quite a lot too, and they're all protected by the Chevron decision to believe that they can do whatever they want and they won't be overturned, because they can't be overturned unless a court finds that they were arbitrary and capricious, which they never do.
Okay, now Fernando, I want you to talk about the areas that you've seen the Chevron doctrine applied, but also, if you could, because you're our street fighter, what's it like for litigation for clients? Because I mean, what are they actually looking at when somebody comes to you and you see that this is staring you right down the gun barrel? How do you deal with it, Fernando? And what are you looking at?
Yeah, unfortunately, you tell them to keep their money and turn it over to the government, because there really isn't much you're going to be able to do for them. The standard of arbitrary and capricious is its own to meet. And this does come up in my area in terms of appealing no-fault decisions that of a master arbitrator, for example, which is where the arbitrary and capricious standard is applied. Also, when there is a vehicular and there's a death as a result of a motor vehicle accident, DMV holds a vehicular death type of hearing, and they will tell you what they're going to accept or not accept. So there have been plenty of times where I have documents from accident reconstructionists, which are police officers, which show that my guy didn't do anything. My guy comes in, sits down, I go, hey, judge, it's an ALJ who's been appointed, it's an ALJ who's being paid $5,000 a year, who's friends with either the mayor or the governor or someone akin to that. They sit there, they look at you and they go, yeah, I'm not taking any of that.
Okay, so then that goes into the whole area of personal injury. So whenever we see these commercials that are out there with, hey, if you've fallen down, call me, I'll get you millions of bucks. I mean, it even affects those cases and their livelihoods. Isn't that right, Fernando?
It does, because in an auto accident, they're going to suspend your license, for example, and they may or may not be able to use that against you.
Okay, I saw Nick's flag. Nick?
Yeah. Well, see, the thing is, those are fair fights. In other words, fair arguments one-on-one. Okay, but see, that's not the situation here. The problem is the general public believes you have a right to the jury trial. You don't have a right to jury trial. The general public believes you can go in front of a judge. Yeah, you can, but it's a waste of time because they're always going to presume the other side wins. Okay, so the general public doesn't know. It's a game. It's rigged against you, and you're going to lose against the government agency. Why don't you teach that in civics course? Let them know that the United States of America is governed by the oligarchs and the bureaucrats, not an independent judiciary. Just teach that in high school and let them know that we operate a system very similar to the Soviet Union and communist China. Not much difference, predominantly because of the Chevron doctrine.
And Nick, we just happen to have a professor on our panel who actually teaches. So Adam, the floor is yours. What are you choosing to teach your students about Chevron?
I teach them that in every area of the law, standards are ambiguous and open to interpretation. And I believe that those ambiguities should be resolved through the democratic process, not by unelected judges. And we see it all over the law. When universities enact affirmative action programs, courts give those programs substantial deference as to their constitutionality. When schools try to regulate speech or conduct searches of their students, courts give them substantial deference. When appellate courts review criminal sentences, including the death penalty, they give the trial court extraordinary deference through what's called the abuse of discretion standard. My simple point is that when there's reasonably different interpretations, don't let courts impose their version of reasonableness. Let the agency do it through Congress. That's more democratic, and that's the right thing to do for liberty.
Okay. Well, you see, Adam, what I'm curious about is this, and I'm just kind of testing the waters here. We know that with affirmative action, which you brought up, that it used to be a broad kind of standard and complete deferral. But we also know that the Supreme Court has constantly revisited affirmative action and has chiseled away at the broad scope of affirmative action. And isn't what Gorsuch and Kavanaugh and all of your colleagues are saying now, isn't that the same natural evolution as a response to the broad execution and infiltration of Chevron into every aspect of our lives? Who gets in, who lives, what money they get, whether or not a farmer has 2 cows or 1 cow. Adam, isn't it?
No, it's an expression of their desire to have power in an anti-democratic way. The last affirmative action case, Fisher versus Texas, Justice Kennedy for the majority said university affirmative action programs are entitled to substantial deference. In the Obamacare case, Chief Justice Roberts said where the Constitution is ambiguous, we should defer to the coordinate branches. That's more democratic. That's the only argument I'm making. I don't believe in empowering the courts. I don't believe in empowering oligarchs. I believe in democracy. I believe in the people. And I believe that where an interpretation is reasonable, courts should stay out of it when statutes ambiguous.
No, I got it. Guidry, because you are my heart and soul on this panel. And you're balanced. You're balanced and balanced. Now, Adam has just said once again, he believes in power to the people, does not want unelected, unknown oligarchs to make decisions, and yet we have here that the agencies who are unelected, unknown, we don't even know if they're qualified, writing these rules and then showing up and telling us what they meant by the rules and saying that we don't count. What is that? I mean, Guidry, can you make sense, please?
Exactly, Bill. You just gave an answer that I wanted to give to Adam's argument, because he's all about the democratic process. But
and agencies are created via the democratic process.
Yes, Adam. Tomato. On the paper, on the cover of the book, it says that. But inside, who appoints? Who makes the appointees to represent those agencies?
Okay.
We do not elect them. They are being appointed, and usually they have their own interest.
It's a delegation of power by an elected branch.
Adam, hang on. Let her make her point.
Adam, but we don't need to look far. You need to look at the Trump administration and his appointees that are contrary, multiple appointees contrary to the agencies and their stand and the precedent that they stand for. When you talk about democratic process, I think about de novo standard. I think about judges making decisions without any influence that they have to take into account. And when it comes to agencies, rational and reasonable standard is absolutely illogical and bizarre. And when really thinking about it in more depth, it absolutely doesn't make sense. As being an attorney and starting with the contracts, reasonable and rational is incredibly broad structure. And when you apply that to the law that is by itself done to really, as Nick pointed, to go as the time things changes and incorporate whatever the agencies or their appointees that were not appointed by democratic process think like, it's bizarre. We'll lose justice and we'll lose that democracy that Adam is really
so you want to give power to unelected life tenured justices. Give me a break.
No.
Okay. Well, listen, hang on.
I just want the judicial precedent to be honored for the judges to make independent decision, not to write the law, but to make an independent decision, and also continue having the separation of powers that we are losing when we give federal government so much power and authority to really manipulate the game, not only set the rules, but also to impose them to everyone.
Okay, we're going to go Jeff, and then after Jeff, we are going to go through our concluding lightning round as we bring this to an end. So, Jeff, please, you started out as a subject matter expert. The rest of us have been arguing. What are you thinking now? Because we have the creme de la creme here on this panel. And Jeff, what's going on?
Let me address something that Adam's brought up a couple of times and nobody has responded to yet. He said when he last spoke that that it's no different to appeal from an agency. There's an appellate standard applied just like there would be in a criminal appeal or anything else. Here's the difference. That's a false equivalence. He is making an equivalence between a trial in the criminal realm. For example, you get a presumption of innocence, you get a right to an attorney, you get due process in all kinds of ways. And the decision maker is supposed to be impartial. When you go and do an administrative agency process, the people judging you are the same people accusing you. So there's a false equivalence between an administrative agency proceeding and a court proceeding, which are both followed with an appellate standard of review, number one. Second thing, I agree with what everyone's saying about democracy. Unelected bureaucrats are no better than unelected judges at interpreting the law, and they are wedded to a particular political point of view. Third, due process. Just if you question, imagine walking into the courtroom when you've been accused of something and you're in handcuffs, and the person who's accusing you, the cop that arrested you, is sitting up there on the bench. It's not fair. It's simply not fair.
Fernando, please.
Yeah, it's I mean, let's face it, we're all right and Adam's just wrong. And we don't have enough time to continue to go through it so that individuals at home can understand this easier, because he has land rights or grazing rights or any of that stuff. Think of when you get a speeding ticket or a parking ticket. You sit there and you look at it and you go, hey, I wasn't speeding. And then you have to go fight it. And then you go, this is a giant waste of time, because in there I'm going to lose, because they're going to say, they're going to take the word. This is what happens when you allow the Chevron deference standard to continue. The deck is completely stacked against you each and every time. You are going in front of the people who are writing the law and who are interpreting the law, and then who are making decisions on those rules, laws, and regulations. There is an aberration of separation of power with this doctrine. It may have had good intentions when it started, but it has evolved with those good intentions. Even get into the equal protection argument that's there also.
Okay.
That you're not getting equal protection under the law when you walk in to a stacked deck.
Okay. All right. Guidry.
When the Supreme Court Justice Scalia mentioned that Chevron doctrine provides predictability, right now I think that in fact he was right, but not in a positive way. It provides predictability that the smaller player, that an individual will always, or most of the times, will have to fight a fight that is against, its unbalanced fight, and supported by agency that has a multiple players involved and multiple agendas that at this point become out of the hand. And therefore Chevron doctrine needs to be curtailed in order to represent and take us back to a more fair possibility to justify what's happening.
Okay. Adam, this is a rare moment, Adam. Please. Okay. We're not starting the lecture. We're ending it, Adam. Please.
For decades, the Supreme Court has agreed with me and not a single member on this panel. Every individual has access to the courts to challenge agencies' actions. Look, I don't like agencies, but you know what? It's better to have agencies than 9 unelected judges imposing law on an entire nation. Jeff, Nick, Guidry, Fernando want to empower the court, you know, that court who decided Dred Scott, Plessy versus Ferguson, with the power to make law for the world, for the country. No, that's not right. When a reasonable interpretation is possible and the courts deem the agency's interpretation reasonable, then they should defer, like Roberts did with the Obamacare decision and like courts routinely do every day.
Okay. It seems to me, as we are nearing the end, just before I hand this over to Nick, it seems to me that this is kind of like the classic problem of the Hatfields and the McCoys. They have a disagreement over a pig. And so the Hatfields, because they have the dispute, the only place that they can appeal to is the McCoys, who are the ones that committed the crime. Now, I don't know how that's particularly fair, and I don't know how the Hatfields and the McCoys, indeed, they've never been able to resolve the issue, but it seems to me that that's currently what's going on with this Chevron doctrine. And as we have heard during this brief time at the lawyer's den, Nick's client is getting hosed for about $1 million. Guidry's clients don't know if they can, start brand new lives here in the United States. All of Fernando's clients who have speeding tickets are going to have to pay those. Jeff and the grazing rights out there, I'm really not sure about any of this, but I do know that the Chevron doctrine touches every single one of our lives. Now, with that, Nick, I'm going to give you the concluding moments, and then please land the plane.
Yeah, I'm hoping that in this session that they actually overturn the Chevron doctrine and put it in its place, because I guess I do disagree with Adam. I believe in an independent separation of powers judiciary, rather than one branch is the judge, jury, and the executioner, which is what's going on right now with the Chevron doctrine. So hopefully we'll see it overturned in this term. It's going to go in front of the Supreme Court. And I think we're going to be able to get rid of it for the first time. And all the lawyers that practice who like an independent judiciary will be clapping their hands, and the government bureaucrats will be whining in their soup because they don't get to push the individual people around. With that, we'll end the plane, and we'll see you next time on Lawyers Net. And Guidry goes, let's go look at something that took place 40 years ago. Who cares? Okay, that's political.